Welcome to CJ105 Criminal Law here at Park University. My name is Bill Bauer, and I'm here to instruct you throughout the rest of this term on various things concerning criminal justice and criminal law. I'm first going to talk about the assignments for week one. Very simple assignment this week. We only have to worry about a discussion board. Okay, now in that discussion board, you have a couple of things you need to do. There are a number of questions listed in the discussion area. You need to select at least two of those. And then research your answers for those two questions and provide those to the rest of the class. Now, the initial answers to these questions needs to be submitted no later than 11:59 p.m. Central Time on Thursday. Okay, that's 11:59 p.m. Central Time on Thursday. Once you've accomplished that, you must also have at least 3 quality or substantial replies to fellow students or myself throughout the rest of the week. Now, by substantial or quality, we're talking about where you're adding something to the discussion about the topic. Something more than just, I agree with you 100% about what you said about blah, blah, blah. Because then all you've done is agree and restate what the other student said. Or give compliments. Compliments are great. You want to give compliments, that's fine, but they're not on topic and would not necessarily count towards your grade for the discussion board. So we're looking for something about the topic. Additional information, hypotheticals, examples, case studies. Something that will add to our understanding of the topic. Okay? Now, one thing I want to caution you on or remind you about is that you need to research beyond the textbook for everything you do in college. The textbook is a wonderful place to get started. It'll give you an idea about the topic so you understand what you're talking about. It'll give you some key phrases that you can use for searches. In the bibliography area of the course, I have provided some additional web links to help you research further into various topics. Into different laws, different topics, their defenses, and so on that we'll be talking about throughout the rest of the term. You can also use and should use the McAfee Online Library at Park University. The McAfee Online Library has a really good group of criminal justice journals, periodicals, and journals and periodicals are where you want to do your research in college. Now, I know in high school I did the same thing. We used to look at books at the library, and those can be helpful in some cases. But books tend to be behind the time. They're not up to date. Even our textbook, you'll notice in your textbook it says copyright 2014 for the 11th edition. Reality is it came out last year. We've been using this textbook since January of 2013. So even now, our textbook could be behind in certain topics. You want to be able to go beyond those. So research beyond that. Look at criminal justice journals. They come out periodically. Look at journals. If you do research at McAfee Online Library and you get a list of, say, 5 or 6 journal articles, use the most current one because that will be the most up-to-date, the one with all the changes. That's what you want to use. You need to do some research, okay? I teach for several universities, and a couple of the other universities I teach at, I have a hard time getting students to do the research. They'll just tell me, well, I believe this is the way things should be. Well, that's great, but does it work that way? Do some research. Find out what really is going on in the world. What are the arguments, pros and cons of different topics, and then present those in your discussion board. You also want to use multiple sources when you're researching for your essays. There are 3 essays during this term, during week 3, 5, and 6. We'll talk more about those in the recorded video, the recorded lectures at that time. So to begin today, we want to talk a little bit about, get a feeling and a background about criminal law. All right, just a background of it. What is it? Where did it come from? So we're going to be reading chapters 1 and 2 in our textbook this week. One of the first questions we have is, what types of acts should we use criminal law for? Of course, we want to have liability, criminal liability for acts that harm others. Murder, robbery, rape, larceny, fraud. That harms somebody, either physically or financially. It harms somebody. We also look for creating laws for actions or activities by individuals that can harm the public well-being. Now, that becomes a little more gray area, because some people will say, well, it's the public morals. That's difficult to talk about, because every one of us has morals. Okay? Even a criminal has morals. They're just not the same as yours and mine. And my morals aren't going to be the same as yours. Yours aren't going to be the same as your brothers or your sisters or your moms or your dads. Everybody has different sets of morals. So when we start creating law based on morality and not on actual harm to somebody, we begin running into a problem. When have we crossed into an area in which we don't really need to use criminal law for? Now, currently in the United States, since about 1980, 1981, our country has used pretty much criminal law for everything. If we disagree with a certain type of activity, it becomes criminal law, even though there may be other ways of dealing with things. When we're dealing with punishment, now punishment, we're not going to talk a lot about punishment in this class, in this course, because what we're concerned about is the crime itself, what needs to be proven. So this is probably going to be the last time I talk about punishment in any kind of detail. Punishment in criminal law is designed to do one of several things, depending on how the judge or how the statute is created, what kind of punishment is given. Punishment can range from retribution, which is the idea of getting even with the suspect, with the offender. Society getting even with that offender. That's retribution. Rehabilitation. That's when we use some other form of punishment that is designed to change or fix the behavior of the individual. Oftentimes we see in minor assault and battery cases, the offender may get a requirement that they have to attend counseling for anger management. That's a rehabilitation type of punishment. They have to go. That's punishment. Sometimes we use fines as punishment. So we got retribution. We have rehabilitation. Another form, another goal or philosophy of punishment is incapacitation. Incapacitation means that we're putting somebody in a position where they cannot commit crimes again, usually incarceration. Serial killers, mass murderers, people who have committed multitudes of very serious crimes will get a sentence like life imprisonment without parole. That is incapacitation. The death penalty is incapacitation. They can't commit another crime. It doesn't deter crime for the future as far as other people committing crime, but it does incapacitate that person for the duration of time that they're in jail or prison. We also have the goal or philosophy of deterrence. You'll see that in the outline and in your book. However, what we've seen in studies and research throughout a number of years is that incarceration, for example, has little or no deterrent value. None. By itself, it has none. Rehabilitation can have some deterrence. If you throw incarceration with rehabilitation together, we may have some deterrence. But the idea with punishment is to try to find some deterrent to keep others from committing this crime. Now, I did a study a number of years ago for drunk driving in the state I was a police officer in. And what I found was, as we increased the amount of time spent incarcerated for drunk drivers, there was no change in the drunk driving rate. or drunk driving accidents. They stayed the same. In fact, when the state went to a felony DUI, for 2 or 3 years after that, the drunk driving rates actually went up. There's many other factors out there that cause drunk driving other than incarceration. And most, let's face it, most drunk drivers don't start out with the idea, I'm going to get drunk and drive. That's not their plan. Their plan is go out, have a good time with their friends, maybe have a couple of drinks. Problem is, as we drink more and more and more, we become less rational. And at some point, we're so drunk that we don't believe we're drunk and we can get home. So there's no thought about how much incarceration might be involved if we get caught. It's just not done. Same with most criminals. I've never met a criminal yet that looked at would research statutes to find out, well, how much time might I get for committing this larceny or this fraud or whatever, or robbery, before I do it. They just don't. What they look at is, can I get away with it if I try? Okay? So punishment has these different goals and philosophies. Now, for the laws that we're going to look at, we're really not concerned with punishment. When you do your papers, you can add in some punishment information if you like, but it's not what we're looking for. What we're looking for is, what is the crime? How is it defined? What does the prosecutor need to prove beyond a reasonable doubt to convict the individual of that particular crime? That's what we're looking for in our discussions and in our research. When we're talking about defenses, what are the different elements that the defense attorney needs to show to prove their defense if they're using one? So that's what we're going to be looking at throughout the rest of this term. Next thing we want to talk about is, where do crimes come from? Where do laws come from? Criminal law. First, let's define the difference between the 3 different major sections of law. There is procedural law. You'll find these in statute books all over the place, but they're procedural. Like if you see a statute of limitations, that's a procedure. It's not a crime. It's a procedural issue. We have to get somebody charged in court by a certain amount of years after the crime has been committed. Okay, that's procedural. We don't want to talk about procedural in this course. This is criminal law, not criminal procedure. Criminal procedure is a whole different course all by itself. When I went to law school, it was an entire semester just in criminal procedure. We also have civil laws in the United States. Now, civil law in the U.S. and England, Canada, any place that was a colony of England, civil law refers to grievances between individuals. Those are the lawsuits, the torts, divorces, contract disputes, product liability, wrongful death. These are all lawsuits. Somebody is suing somebody else, whether it's a person suing a person suing a corporation suing another corporation, whatever. We're looking at, it's a lawsuit deal. It's not criminal law. That leaves us now with criminal law, right? Criminal law is something that is a statute, a code, an ordinance that tells us what we cannot do or what we must do. And we all know what we cannot do type laws. We cannot rob somebody. We cannot commit larceny. We cannot commit burglary. We cannot murder somebody. We cannot rape somebody. We cannot counterfeit. We cannot. These are the things we cannot do. But what a lot of us don't, many people forget, or maybe they don't even know, is that there are some laws that require us to do something. For example, if you get in a car accident, your state probably has a statute that says you must stay at the scene of the accident. You must exchange information with the other driver. Okay, those are laws that say you must do something. And if you omit doing that, committed an omission, then you have violated that law. Now, the other part about a criminal law is it tells us what we have to do or cannot do it also sets out a punishment. If there's no punishment in the statute, if the statute doesn't say whether it's a misdemeanor or felony, whether there's a fine set or whatever, if there's no punishment involved listed in that statute, there's probably going to be a procedural law or a civil law, because those don't have punishments involved. So when you're looking for a statute, a code, an ordinance, be sure to look to make sure there's a punishment involved with things. I've had students in the past that are doing their research for, let's say, larceny, and they'll give me a whole bunch of punishments, but no action. What aren't you allowed to do? What is it the prosecutor has to prove? Or they'll pull up, had one, somebody in another school give me the statute for statute of limitations for a crime. Well, that's well and good, but that's a procedural, and if they'd have looked further, there's no penalty for what they were reciting in their assignment. So you want to make sure you're looking at actual criminal law, not definitions, not procedural. Pretty much every criminal section in your state laws will have definitions as well. Those just define words that you'll find in the later statutes. Okay? So that's some of the things we're looking for. Now, of course, I mentioned felony and misdemeanor a moment ago. Let me get back here. We all understand that. Different states will differ slightly in how they define a felony versus a misdemeanor. In general, what we're looking for is felonies have incarceration rates of a year or more in a state prison. Okay, so that's what that becomes a felony. Now, they may also have fines. In fact, most felonies will have, it's 18 months in federal, 18 months state penitentiary, and possibility of a $10,000 fine or something. They can be together, and they can be sentenced together. But the idea is a felony is possibility of incarceration of 1 year or more in prison. Misdemeanors are less than 1 year, usually in a county or city jail. Now, some states even define it further and will have petty misdemeanors. Petty misdemeanors in some states will be less than 6 months in possible incarceration, or less than 3 months possible incarceration. we won't define it quite that far. Felony misdemeanor is good. More importantly is understanding the category of the crimes fall into as far as mala in se. Let me give you that here. Mala in se and mala mala in se and mala in prohibita. Now these are, can't get in there. All right, these are Latin terms, of course. I don't know about you, but I hate Latin. When I went to law school, I hated Latin there too. I always have to look them up. Mala in se means that if a crime is mala in se, it means it is evil of itself. We know what kind of crimes are evil of themselves. Murder, robbery, rape, burglary, larceny, embezzlement, fraud, counterfeiting. These are evil of themselves because they harm somebody, either physically or financially. So these are evils of themselves type crimes. Now, mala in prohibita are crimes that have been created over time because society wants to have them. All right? Prostitution is mala in prohibita. It was legal at one time. It's currently illegal in most areas of the United States, except for parts of Nevada. Gambling, mala in prohibita, it used to be legal. It's not evil in itself. It's just a behavior that at one point or another, the social norms said, we don't want to have it. Now, of course, gambling is a great example of mala in prohibita. Used to be gambling was open anywhere. You could gamble anywhere. Then it became illegal everywhere in the United States. Now it's changed back to where certain places still have gambling. Parts of Nevada have gambling. In fact, all of Nevada, you can gamble. New Jersey, you can gamble. Certain other areas have gambling associated with Native American reservations. Okay, so we've gone from being completely illegal to being completely illegal to now where it's only illegal in certain places but legal in other places, and will probably continue to change over time. So mala and prohibita isn't evil of itself. Those kind of crimes can be changed. Drug use, drug dealing, those are mala and prohibita. They're not evil of themselves, because people have been taking drugs since the beginning of time. Alcohol is a drug, tobacco is a drug. So we've been taking drugs forever. So it's not mala and prohibita. It's not evil of itself. It's just that we don't want certain people, we don't want certain drugs being used in certain ways. And so we've created laws prohibiting it. Now that doesn't mean that somewhere down the future those laws won't change. And we're already seeing those laws change. Many states now have medical marijuana laws that allow use of marijuana for medical reasons. Colorado and I believe it's Oregon have legalized it completely. Just smoke marijuana if you want, just as long as you're not driving or doing something other that you couldn't do if you were drinking alcohol. Other drugs may change in the future. So we have mala and say, evil of itself. Mala and prohibita. It's illegal simply because we said so. Now, how do we create laws? What are the sources of law? Okay, let's do sources of law first. Sources of law in the United States. 49 of the 50 states in the United States got their statutes, got their laws from what we refer to as common law or English common law. I like to use common law as it applies to historical England hundreds of years ago, and court decisions today as laws of precedent or court decisions, although they are kind of the same because they were created by judges. English common law began in the 11th century. We see the beginnings of it during that time after the Norman Conquest, and it developed over hundreds of years. It's not like today where state legislature passes a law today, tomorrow the governor signs it, goes into effect a month later, and you've got a law. The laws in England, the common law, developed over hundreds of years. And they were developed by the judges for the crown, the king's judges. They would go around to different villages and towns to hear complaints from people who thought they were wronged. Maybe a pig was stolen. Somebody tried to burn their house down or did burn their house down, broke into their house and stole something. But they're complaining about something, and maybe the offender has been caught. So now the judge has to do something. Now, at that time, there were no written laws. The king, during each term, or each king that was we would see over these hundreds of years, would have some parameters. Who could complain, who couldn't complain, things like that. And maybe for certain things would have some input. But a lot of what we see in English common law is simply the customs and norms and morals or mores of the villages and towns. And these judges discovered that many of these towns and villages define crimes the same way. And so they took all this and developed judge-made law, or judge-made elements of crime to define what the crimes are. Now, when the colonies were founded, the first 13 colonies of the United States were founded, the colonists brought these laws with them. Then after the Revolutionary War, well, now we've got 13 states. These 13 states then began, after the Revolution, to begin to statutize or encode these laws. They wanted to make them firm, make them solid, something that was well defined. Every judge, every law enforcement officer, every person could understand what that law was. And so they were codified at that point. Now, some states, Georgia, Virginia, Maryland, some of the states, particularly along the East Coast that were of the original 13 colonies, will still relate to common law. But they'll normally have a statute that says, for example, the law of murder is as described in common law with the exception of, and then they'll define first degree, second degree, manslaughter, and so on, or they'll have court decisions that do it for them that are listed in their statute books. So it's still written down, but they're relying on the original Old English Code, or Old Common Law. So that brings us to the next source of law. Federal codes, that's what we call them, federal codes. There are federal criminal laws, state statutes, county ordinances, city ordinances, and so on. Those are other sources of law. Of course, going back again, another source of law is court decisions. Judges make decisions every day. And sometimes a decision at like the trial level really won't have much impact, but once it gets to the state appellate court or the state Supreme Court or the federal circuit court or the federal Supreme Court, then they start having impact. They become laws of precedence. Other courts have to follow that decision. Okay, so when that's a form of law. The U.S. Constitution is a form of law. Now, there's only one real criminal law listed in the Constitution. It's treason. It tells us, defines what treason is, tells us how we have to prove it, and what the possible penalties are. It's the only one listed in the U.S. Constitution. But the Constitution still sets out limits, laws, if you will, setting out limits on what kind of criminal laws we can have. And we'll talk about some of those limits later. U.S. state constitutions, there's 50 states, all 50 of them have constitutions. Those do the same thing as the U.S. Constitution, but at the state level. Then we also have regulatory agencies, federal, state, county, city, that set up regulations. For example, the IRS has regulations on reporting taxes, what can be reported, how you report, and so on. Game and Fish tells us when we can hunt, when we can't hunt, what we can use for hunting purposes, how many, like, what's our bag limit, what's our limit on number of fish, and so on. They all have regulations. Security Exchange Commission, lots of different organizations, agencies at federal, state, and local levels that have regulations. And they have the effect of law. Because if you violate one, you're looking at a minimum of a fine, possibility of jail time for certain types. Certainly violating the IRS, you could end up in federal prison for that. You could have your vehicle, in hunting situations, you can have your vehicle, your weapons confiscated, possibly forfeited back to the government. You'll never see them again if they were used improperly, used for poaching purposes. So these are different areas that we find law in. Constitutions, statutes, codes, and so on. I did mention earlier that only 49 of the 50 states use English common law. How many of you can guess what the other state is that does not? I'll give you a second. Time's up. Louisiana. Louisiana originally was a French colony. And as the Louisiana Territory was sold off and it became other states, the actual part that was the original part of the French colony, Louisiana itself, maintained its laws based on what we refer to in Europe as civil law, based on Roman law. Okay? So that's where we get our laws from. Now, the United States, we just talked about, we have federal codes, we have state codes, we have local codes, statutes, and what laws. because we are a country that uses federalism as our form of government. The U.S. government, the federal government, has certain powers enumerated in the U.S. Constitution. If you look at the 10th Amendment essentially says that any powers not specifically given to the federal government in the U.S. Constitution belongs to the states. That's why we have the division of 50 different states having laws, plus the U.S. government. And they will, although they're very similar, they do differ at times. So, let's see here, where am I? Let's look at crimes themselves now. Now, crimes have elements, okay? Elements are the things that a prosecutor needs to prove to get a guilty plea. To get a guilty conviction. Okay, those are the things they have to prove. That's what we're going to be talking about. That's what we're going to be researching, we're going to be discussing. That's what your essays are going to be about, are the elements, the things that must be proven in court, how they're proven. Even when we look at a defense, there are elements to a defense that need to be proven by the defendant, because they're normally going to be affirmative defenses. Affirmative defense means that the burden of proof shifts briefly over to the defendant to prove that they have this defense. Then the prosecution has the burden of trying to override that defense. Now, there are two general parts that we see in crime, in criminal law. Excuse me. One is called general part. General parts are the things pretty much all laws have. You got to have criminal intent. You got to have a criminal act. Those are the general parts. Then we have the specific parts. Those parts that that actually define the specific crime involved. Okay. If we looked at general parts for larceny and burglary, for example, it's taking property, right? That's one of the general parts. It could be in both. But the difference comes in the specific part for burglary is you have to have breaking and entering or unlawful remaining in a structure for the purpose of committing that theft. Makes it different. So we have the general parts and the specific parts that we can look for in some of these crimes. There are different areas, of course, and at this point it's a good idea just to take a quick look at the different areas that we have law in. For example, we have laws against crimes against the state. We're going to talk about that at the end of the term. Crimes against the state are things like sedition, treason. They're crimes against the government. Okay? Then we have crimes against persons. So the crime is directed right at a person, like murder, robbery, rape, assault, battery, kidnapping. Those are crimes against persons. Now, going back to robbery, robbery can really fall either as crime against person or crime against property, because it does both. Because robbery is actually an assault with the purpose of committing a theft. It can fall in both places, which brings us to crimes against property. Crimes against property are directed at property. Burglary, larceny, fraud, embezzlement, counterfeiting, all of those types of crimes are crimes against property. And they take up the vast majority of criminal actions that a court will hear. We have then crimes against public order, crimes against public morals. As I mentioned earlier, those are difficult. Crimes against public order can be things such as prostitution, gambling. Those also will fall under crimes against public morals. Disorderly conduct, disturbing the peace. Those are public order issues. Certain areas, certain states will have laws that regulate where people can go to protest. For example, if you violate that, that's a public order issue. Public morals, again, gambling, prostitution. Drug use is probably public order because it's not really a moral issue. It's more of a public order issue. And then we have crimes against the administration of justice, like perjury. Okay? So those are different areas. Now, your essays, two of them are going to focus on two of these categories: crimes against property and crimes against persons. We'll talk more about those when they come up. The essay for crimes against persons is week 5. Crimes against property is week 6. Week 3, you're going to be doing an essay on either parties to a crime or one of the inchoate crimes. We'll talk more about those when we get to that week. So we've gone through these sources of law. We've gone through some of the other issues. One of the things that you're going to be talking about is the democratic limits, or how does a democratic government or society limit law? Very simple. How do we get a law passed? Okay? Very simple. We have to elect legislators or congressmen, city council members, county commissioners. We have to elect somebody to office that has the authority in a legislative body to pass laws. Of course, the majority elects those people. So essentially, the majority of people, when somebody's elected, the majority is saying, we elect you to represent us in passing laws. So now we've just limited what laws can get passed because the other guy lost. Not only do we elect those people, but once the legislative body, whether it's state legislature, Congress, or whatever, has passed a law, it still needs to be authorized, okayed, approved by another elected official, the executive head. For the United States, that's the president. For your state, it's the governor. They are elected, they're your representative, they still have to pass it. Now, once a law has been passed, it's still, in a democratic society, is facing things called the court. Courts not only look at whether or not a person has violated the law, they also look at whether a law is even legal, whether it's constitutional. If the law is found to be unconstitutional, a trial court could say, I don't think this is constitutional, we're not going to go by it. And then kick it up to the appellate court. And the appellate court says, we agree with the trial court, this isn't constitutional. It's limited. That law has just been thrown out. So we limit it through the use of elected officials that the majority of the public elects, through the use of the courts that adjudicate the validity of that law based on the U.S. Constitution and state constitution, if you're in state court. So we have these kind of limitations involved in creating law. We're going to talk more about those limitations as we go along here. Now, the United States, in fact, we're going to talk about it here in just a moment. The United States uses what we refer to as the rule of law. Some of you probably have heard of the rule of law before, seen it in the newspaper, especially since the war in Iraq and Afghanistan and other places around the Middle East, because much of the Middle East does not use the rule of law. The rule of law essentially says that all laws must be fair and applicable, applied to everyone equally. Okay? Now, in many of those foreign countries, even in Asia and Africa and places, there is no rule of law because the law is only applied to certain people. For example, if you go to Korea, North Korea, there are a lot of laws that are going to apply to the everyday citizen that Kim Il does not have to follow. He's the leader. He's a dictator. The law doesn't apply to him. In fact, no law applies to him. He can do anything he wants. So there is no rule of law. After the wars in the Middle East, we began sending lawyers and judges to the Middle East, other legal representatives, to help them develop laws that follow the rule of law. In fact, if you look at Iraq's laws today, as compared to when they were under Saddam Hussein, Many of the laws now apply to everyone, the way they're written anyway. Now, how they're actually applied, there might be some question about. We'll have to see how they adjust. But the rule of law in a democratic society says that everybody has to abide by the same laws, from the leader on down. Now, I mentioned we have limitations in the Constitution that the courts will decide. Now, a few of those limitations we're going to talk about in the class this week, one of which is ex post facto. Ex post facto. Let me write that down here. Ex post facto. Okay? Ex post facto laws are laws that are created to apply to an act that occurred before they were passed. Okay? Simple way of looking at it. Let's say that yesterday you could walk down a sidewalk in your city chewing bubble gum and popping bubbles. Today we passed a law saying you can't do that anymore. It's against the law. The passage of the law means that acts after the passage can be punished. It can be charged. But we can't go to yesterday and say, oh, I saw 3 guys yesterday chewing gum and blowing bubbles walking down the sidewalk. We're going to charge them because now we have a law. We cannot do that. Ex post facto is a limitation that prohibits going back and charging an act that was legal at the time with a new law. There's 2 other ways that ex post facto works. We cannot also increase a sentence or punishment for a criminal act that occurred before the punishment was increased. So if we were to say drunk driving, we don't have, yesterday somebody was caught drunk driving, and yesterday the law said that the maximum they could serve or their maximum punishment would be a $100 fine and 30 days in jail. But today we passed a law for the exact same act that occurred yesterday and say, no, now it's 6 months in jail and a $1,000 fine. The punishment that we passed today cannot be applied to the crime that occurred yesterday, even though that person that was caught yesterday or committed the crime yesterday doesn't go to court for another 2 weeks. Okay? The laws that are enforced at the time the crime actually occurs are the ones that are applied. We cannot increase the punishment. We cannot create a new law. And the third thing is we cannot take away a potential defense that the offender had available to them at the time of the crime by passing a new law today. The idea in ex post facto is to provide fair warning. Everybody's entitled to a fair warning. If you do this, this is what's going to happen to you. It wouldn't be fair to say, if you do this, nothing's going to happen to you, and then tomorrow say, oh, we changed our minds, now we're going to come back and get you. Okay? It's not fair. Not fair warning. In the United States, we pride ourselves on fairness in our criminal justice system. Another limitation is called void for vagueness. This one's sometimes hard for people to understand. Everybody thinks that laws are very vague and hard to understand. Reality is criminal laws are pretty simple to understand. You can't do something. You can't do that. You can't do this. So they're fairly simple to understand that way. But if a law is written in such a way that a person of average intelligence could not understand what is being prohibited or what act is being required by the law is unconstitutional. Okay, so it has to be written in a way in which it's clear what you are not allowed to do or what you are required to do to keep from getting in trouble. Now, sometimes laws are written that are void or are vague, and so the void for vagueness limitation applies. They become unconstitutional. The part that a lot of people don't understand is, in this part, is that the definition is a law that an average person could not understand. We're not talking about the offender, okay? When we're looking at the constitutional issue, we're looking at society as a whole. So anytime you see a case in which they're looking at a constitutional issue, it's not specific to that particular case. It's general to the entire public. So when somebody's charged with a crime and their defense attorney says, we object because it's void, it's vague, it should be unconstitutional, the court then has to look at it as whether any average individual would understand what that law is about. Another limitation on law we find in the 14th Amendment, called the Equal Protection Clause. Now, many people understand the Equal Protection Clause, meaning that laws can only be written as long as they don't discriminate, or the law that has been passed cannot be applied in a discriminating manner. That's generally correct. Yet it's not an absolute limitation, because there are some laws that discriminate and yet are perfectly legal. I imagine in your state, your city, you have laws that say today that smokers are not allowed to smoke in restaurants any longer. A smoker, that's discriminating against a smoker. But the Equal Protection Clause does not protect them, because it's not a discrimination that has to be covered. So what we're looking for is classifications of people. You got smokers, non-smokers, you got drinkers, non-drinkers, you got people of different religions, you got different males and females, you got people, they're legal aliens and illegal aliens, you've got just all kinds of classifications. So what the court has done, the U.S. Supreme Court has done, is created 3 tests. And in these 3 tests, we can see why it's not an absolute limitation. The first test is called strict liability. This protects highly protected classes of people for race, nationality, religion, First Amendment, all those really voting. All these are very important rights, or very important categories, and they fall under strict liability, which requires the state, puts the burden of proof on the state, the government, to prove that the law has such a overriding need above and beyond the need to protect that classification of people. Really, really difficult to prove. And the government has a difficult time proving those kinds of cases. The next level is called intermediate scrutiny. It usually focuses on things such as gender, age, alien status. The proof of burden is still on the government to prove that a particular law that they're passing or have passed has a substantial purpose, not a huge overriding purpose, but a substantial purpose in protecting society, which is more important than protecting that particular category of individuals. And there's no other way to do it. It's not as hard as strict liability to get past, still very difficult. Then we have, for all other classifications of people, rational basis. Rational basis covers all other classifications. It could be smoker, like I said, smoker, non-smoker, alcohol drinker, non-alcohol drinker, motorcycle rider, non-motorcycle rider, and so on. Rational basis places the burden of proof, proving that this is unconstitutional, on the complainant, the citizen normally, or the group, the category of people that are looking to have it thrown out on constitutional basis. This one is very simple for courts to get past. That's why it's perfectly constitutional to have a law that says that smokers cannot smoke in a restaurant. All the state had to prove was that there was some harm to the non-smokers, which secondhand smoke was sufficient. Very easy for states to get passed as long as they have a rational reason for having the law, which most laws will fall under because everybody else is a category outside of those highly protected ones. So those are limitations on the law. We also have, of course, the First Amendment. First Amendment is the freedom of speech. We all know that, freedom of speech. Okay, but it's also freedom of the press. It's freedom of religion. It's freedom to associate with others. And when you start seeing some of the cases that we are starting to see dealing with the NSA and so on, we're starting to see more of people focusing on the right to associate, the right to get together and complain about the government, and those kind of things. So First Amendment, highly protected. It's a strict scrutiny test if you go into equal protection. But it's certainly a limitation on law. We can't write a law that impacts somebody's First Amendment rights, whether it be religion, association, speech, or so on, unless it violates some other. Now you'll see, you may see if you do some research, certain religions that have tried to get identified and allowed to break certain laws. Let's say, for example, somebody creates a religion and they want to sacrifice virgins. Okay, they're not going to be allowed to. The law is going to be against them, and it's going to be allowed under strict scrutiny, Equal Protection Act, and First Amendment rights, because now they're violating somebody else's rights. Heavily violating the virgins' rights, of course, because they're the ones getting killed. But if you look at some of our Native American tribes, particularly out west, where peyote is used in religious ceremonies, peyote is an illegal controlled substance in the United States. But under the First Amendment, under the Equal Protection Clause, they are allowed to use peyote for their tribal religious ceremonies. That's it. Okay? And we've pretty much covered everything. One other thing you want to make, one other limitation we have is called the Eighth Amendment, cruel and unusual punishment, which can apply at any time. Most people view the Eighth Amendment as cruel and unusual punishment if you get convicted of a crime. That's the majority of the time when we see it, but it can also be applied to actions taken by law enforcement. It can be taken by actions taken by the courts. For example, there have been some cases where officers have used brutality, beating the subject into the ground, like Rodney King case. I'm not going to get into a debate about Rodney King, whether or not he violated the law or what happened there, but it's fairly obvious at the last portions of the videotape on that case, he was down on the ground, he's getting beaten pretty severely. This can be considered a violation of his Eighth Amendment. He's being punished for crimes he hasn't been convicted of yet. Cruel and unusual punishment. It can also be a violation of the Fourth Amendment because that covers arrest. Okay, so the Eighth Amendment also places limitations on our laws. The Fourth, Fifth, and Sixth Amendments do not place limits on law so much as it provides for due process, which is a whole different issue to discuss. Limits on law themselves, we see the First Amendment, we see the Eighth Amendment, both of which limit laws. The Equal Protection Clause of the 14th Amendment limits laws. And of course, we as citizens limit the passage of laws as well by telling our legislative bodies, with the state legislator or our congressman, hey, we want this law or we don't want this law. It's up to us to decide. That's all I have for week 1. If you have questions, be sure to contact me. My cell phone number is in the office area of the course. The office area also has a place for you to ask questions. If you have a question that may be beneficial for all the students in the course to understand and use the office. If you have a question particular to something you're working on that you don't really want everybody to see or respond to or whatever, then send me an email directly to me. Be sure to put CJ105 in the title box so I know what class you're from. Okay. You probably noticed earlier I said I teach at several colleges. I teach for 3 different universities, and for Park University I teach 2 different courses currently. And it's very helpful to me to know which class are you from, particularly at Park. I don't know if all you do is send me an email, it's going to be hard until I read everything to know where you're from, which course you're in. Okay. Again, my cell phone number is also available. Students call me all the time asking questions when they need something immediately. I just ask that you do it during normal hours. I'm on the Eastern time zone. I'm in Michigan, Eastern time. So please be sure that you pay attention to the time. If you're in California, Hawaii, Alaska, and it's 9 o'clock your time, you probably don't want to call me. I'll answer the phone. I'll answer your question. The only thing I can't guarantee is it will be a good answer. Okay? If I'm asleep and you wake me up, I will give you an answer, but the next morning I may be wondering, did I really talk to somebody? Okay? So it's a good idea to do it during normal hours. Hope you all enjoy the course. Be sure to do your research. Go outside the textbook. Learn something about criminal law that you thought you knew. You're going to find out you may not have known, and certainly will put you head and shoulders above your best friends, your relatives, when you want to discuss things over dinner. Okay? So that's it. We'll end this particular lecture at this time.